Freedom law fathers of this country. And by freedom law father, I mean someone who really went out there and did things and created things when there was no one else to teach them. See, folks, I had it easy. I had these wonderful guys I brought here to you. You heard about some of them. You heard like Bill Conklin, you know, and you're going to hear this next speaker and more that have done the work when there was no one else to teach them. So, and hopefully I've done what they've done easier for you, but this guy went out there and did it when nobody else there was there to teach him, and he had tremendous results beating the IRS and other corrupt government agencies time after time after time. This speaker was formerly a stockbroker, and he was into economics, into von Mises' philosophy and School of Economics. And as such, he got introduced to the Federal Reserve System and the corruption, and eventually founded an organization called Freeman Education Association, which is still going on. He started that back in 1983, 16 years ago. And he has assisted many individuals in beating the IRS. So you don't have to be afraid of the IRS, folks. When you hear those little three-letter words, I get excited. I don't know about you. I get excited. I thought, yay! You know, we'll tell you more fun stories, but I want to bring Vern Holland up because he's had tremendous amount of success out there in the freedom movement, you know, unlike very few in this country. So please help me give a warm hand of welcome to one of the most foremost anti-IRS tax specialists in America, Mr. Vern Holland.
We're in trouble now. Got to watch the speakers. I see all the gray hair. You know, the guys I've known for a long time. So I tinted mine a little bit, okay? Yeah, it's usually brown. You bet. A lot of people I've known. And, you know, a lot of good times, a lot of bad times. We are having an effect. You know, I can see it. A lot of the speakers I'm talking to, as far as, you know, we've kind of devolved into what we do now as far as helping individuals out. And so we can tell by the number of telephone calls that we're getting, et cetera, as far as what's going on out there. And I don't know if it's just unique with us, you know, or if it's unique with the entire system. But, you know, the number of criminal investigations are substantially down. The number of criminal indictments are down. Seizures in cells are down, you know, and sometimes, you know, my phone doesn't ring. I'm going, geez, you know, but my goal was to put myself out of business. And I'm starting to look for other things to do. You know, and or maybe the Republican Congress had a bigger effect than I was thinking. You know, I mean, they boxed their ears around a little bit, you know, bruised their egos, but you know, maybe there's some things going on behind the scenes that we're not privy to. But things, and this is going, you know, a trend that's been going on for in excess of a year now. And so, yeah, the RICO statute. And so, you know, I don't want to, yeah, I'm not going to get optimistic yet, but things are changing. And I'm seeing judges, you know, finally step up to the plate and start acting like judges. You know, we just had the Fourth Circuit just a handful of weeks ago strike down some additional federal legislation as unconstitutional because it wasn't authorized by the express provisions of the Constitution. You know, I'm going, whoa. Now, we did have, you know, as a 2-1 decision, you know, we did have one dissenting justices, but, you know, we got two that struck it down. And, doggone it, I might get optimistic one of these days. But, you know, it's been quite a price. You know, I think Payment mentioned I used to be a stockbroker. And, you know, I don't know if you guys are watching this massive Fed monetary creation that's all gone into this asset bubble that we call the Dow Jones Industrials and the New York Stock Exchange. You know, it's going to be entertaining when that sucker finally busts. I mean, you know, that's where the money creation, you know, we're not seeing it at the price level. We're seeing it in the stock market as a hotspot. And, you know, I find that fascinating. It's something I like to keep up with, you know, because of my background. But one day I was going downtown. We were going to have lunch, and I went stopped by this bookstore, and it was American Opinion. Never heard of it before. You know, American Opinion. I was looking for specific economic books, you know, by the Austrian School of Philosophy, and like economists by the name of von Mises and Hazlitt, etc. And I just happened to look in the window, and there they were. And Joe, I got an armload of books, and I was leaving, and this guy, you know, kind of bugs me a little bit, and he wants me to buy this other book called Miracle on Main Street by Tupper Saucy. Anybody heard that? Okay. You know, the guys that have been around for a while, you know, yeah. And then, you know, this funny-looking yellowish cover book on how anybody can stop paying income taxes by an author by the name of Irwin Schiff. I said, no, I'm really not interested. You know, I just want my econ books, thank you. And anyway, the guy convinced me into buying the books, and here I am. Reading is dangerous. I'd like to kind of go through, well, let me go through a little bit more of my background. You know, some have heard me speak before, but I was founder of FEA in March of 1983, and you know, when he brought up 16 years, I went, duh, you know, wow, has it really been that long since FEA's been around? Yes, you know, we survived. You know, I've downsized the organization because things are changing, you know, and in a few years, I'm optimistic that I will be doing something else. You know, this is, you know, constantly fighting the government, whether or a government agency like the IRS or a municipality, et cetera, wears on you after a while. You know, it's really stressful, and you know, and just knock down, drag out fight. You know, my criminal process ended about 5 months ago. It started in December of 1986. 12 years. You know, it's a long time, you know. They had me under indictment for 5 years. You know, they ran me through 4 grand jury investigations prior to that. You know, I was subjected to a 30-day criminal trial in August, September of 1990. It ended up in a mistrial. Then you have those enjoyable moments when 5 of the jurors join FEA after the trial. Jury foreman's a real good personal friend of mine today. She decided to go initially to law school, but opted to become a paralegal. And so my criminal indictment extended for such a long period of time because I kept putting up legal barriers to stop a retrial. And that, you know, she became a paralegal and sat as a paralegal for one of my attorneys at a subsequent hearing, you know, a couple years later. And you've heard of those Polaroid moments. And if you've ever watched, you know, or if you've been in court, you all stand up and introduce yourself for the record. And they ask for Susan, you know, she stands up and, Susan Mason, you should have seen that judge's face when the light went off as far as who she was. And the prosecutor, you know. And the prosecutor was such an unhappy individual that, you know, if you heard these people, he just had these lines straight down. And so in our newsletter, you know, we used to say, you know, if you stood him on his head, he'd have a happy face. But, you know, it was one of those moments, you know, when it dawned on them that the jury foreman was now acting as one of our paralegals. You know, and so they knew that they were going downhill. You know, we finally ended it. But anyway, you know, it was over a 12-year period. But during the interim there were several different legal theories that we came up with, and initially, you know, we were taking on everybody. I mean, you know, the municipal government, you know, the state governments, you know, the federal government, you know, every agency that we could think of that we disliked, you know, we took them on. And like, you know, I got involved in the driver's license issue and decided to get rid of my driver's license, and did well for about 11 years without one. You know, but, you know, that got old as far as that kind of a hassle, you know, and frequent court appearances, specifically back during the middle 80s. And, we came up with some nifty legal defenses, one of which was called the verified complaint. And we won literally hundreds of cases on this, and we finally moved it up to the highest court in Oklahoma, and we had 2 published decisions on it. And, this issue got all over the country and fairly rapidly. What just happened? Was that me? Oh, was that better? A little bit closer? Okay. Boy, I sound like I'm just roaring, though. And so we came up with the issue called the verified complaint, and just, it was an issue that you could go in and challenge, what we refer to as the subject matter jurisdiction of the court. And I finally got around to writing a little book on it, about 3 or 4 years ago. And, I've got, just a handful of these back there. But, we go into the legal concepts, which is very important. And the way that you can beat these governments is when they make a mistake. That's how you can beat them. It's called due process. If they violate your due process rights. Okay, and so there's a unique way that they have to invoke, the subject matter jurisdiction of the court, even though the legislative bodies have given these courts jurisdiction. But to get there, I've got to explain subject matter and in personam jurisdiction. I've got to explain indictments, informations, etc. But these are things that, if you're throwing rocks at a governmental agency, you shouldn't know now, because they might throw a rock back. And, at one time I had so many cases going, my head was, just swimming, in all of it. But I've been lucky, and in the vast majority of cases, I came out with a little damage or outright wins in many of them. But, that was a tremendous issue. Got involved with the city of Broken Arrow, where I was living at the time, which, it's a suburb of Tulsa, about 100,000 people. And challenged them on this, but I didn't bring, since it went to the subject matter jurisdiction of the court, I could bring it up at any time. I didn't have to make a record now. I could pop it later, and so I did. And so, I kept the issue back. And we played around for about 14 months after a particular, arrest. This time they were looking to arrest me. They wanted to catch me driving, and so they were keeping surveillance on my home until they finally caught me. And, of course, that was one of those moments, when I'm trying bracelets on over the hood of a police car. And all the neighbor children ran in to get the moms and dads. And, what are they doing to Mr. Holland? God, what's he done now, And so that went on for about 14 months. And we had all kinds of different things that occurred. And, it cost the city of Broken Arrow a fortune. And we finally get to trial, and I had another one of those moments where I'm not going to participate in the trial because I don't care, and by this time I don't need any more practice in trial. I've already been through several of them, including jury trials. And so I sat down, but I did tell the judge that I hope there wasn't any bad feelings, and that this entire process, and it had been extensive, and a lot of feelings said, tempers are flying, etc. But it had been an educational process for me. And I hoped it had been an educational process for them. And that after they found me guilty today, after the trial, that I was looking forward to getting another ticket so we could do it all over again. And then I looked forward to working with them, on my trial de novo to a real court. And from there to the Court of Criminal Appeals, and from there to the United States Supreme Court. And that we'd probably get the judge and the prosecutor, when I said that, they looked at each other. They started laughing so uncontrollably that they were crying. And then I went and joined everybody else behind the bar and watched the trial, and won on appeal. The appeal took about 20 court appearances, and every time I was there, the city of Broken Arrow was there. And I kept telling them all the mean, wicked, and terrible things I was going to do to them, once I won the case. Well, I didn't. After it was over, well, where are we now? I said, I'm not going to do anything. Just leave me alone. Well, they did for 5 years. And then they towed a van. And I know it wasn't a very pretty van. And I know that the paint kind of looked like rust. And I know that it didn't have a valid driver's plate on it. And I know the inspection sticker was expired. And I know it was uninsured. And I know that periodically it was driven by an unlicensed driver. And I know that the neighbors had called in several complaints, and I think one of them was my wife. So I would move the thing. That was a real eyesore, but it was mine. And I know that it wasn't parked properly, and it was in violation of very numerous and sundry ordinances. But they towed it. And the interesting thing about it was the ordinance did not provide for a prompt post-deprivation hearing, which simply means that, hey, you took a property interest of mine. And if you have the right to take it first and then talk later, it's got to be prompt. And you've got to give me the opportunity to challenge the validity of the underlying reason that you took the van and that you towed it. And the towing company didn't know at the time that he towed it in that he was engaged in conduct that was under the color of law, implicate him in a civil rights suit as well, even though he wasn't a government employee. Well, he did find out that that could happen. And about $30,000 later. And I know that for his attorney, I know that seems excessive, but it was a $20 ticket. And I do know, that the city of Broken Arrow cost him about $100,000, to do this. My federal judge that also handled my criminal tax case and others, who constantly reminded me that I was only one case and he had 600, and that I was consuming 15% of his judicial time, and I was only one case. And I was kind of disappointed myself because I wanted 20%. Can you imagine how many other people they couldn't get to while they're messing with me? And so, I don't know if his feelings are changed, but the last time I spoke to him, he didn't think very highly of me. But that case, it culminated in a 7-day jury trial in federal court. I got to take the depositions at an extreme cost to me, but I was compensated for them later for a few $1,000s in deposition costs. But I got to chit-chat with the mayor. I got to personally meet all the city council members, and I got to ask them questions. I got to meet the chief of police. I got to meet the desk sergeant. I got to meet the guy that gave me the ticket, and towed the van. And I forgot to mention, there was a lot of placard residue on the van. You ever seen these orange, ugly things that they stick on a car that gives you X amount of time to move it before they tow it? Have you ever tried to peel one of those off? Man, you can't get that sticky white stuff off, and they put so many on there that, I couldn't see if I wanted to drive it, out the window. But, they can't, they just couldn't get it right. And so that's what I found works within this system, is you examine these statutory schemes and pick them apart, and you look for ways that you can beat them. I had other issues in there. I had a ton of issues. They were constantly complaining about the volume of paperwork that I had filed. But, I also bury in my paperwork the issues that I think the guys that wear the black robes are going to enforce. And I want something to, I figured out early that I like to win. I don't like to lose, and it feels a lot better to win versus losing. And so on that particular issue, the federal judge found the ordinance unconstitutional because it did not afford an individual a prompt post-deprivation hearing. And because, and although the jury didn't see things my way, and the jury didn't even want to award me nominal damages for the violation of a constitutional right, the judge had to revert, not even a penny. We had it down to 1 penny to 99. The judge had to award me $1 in damages for the constitutional rights violation. Wow. I brought, and I also had to take the case up to 10th Circuit in reverse to get the thing to appeal. You know, it lasted about 2.5 years. But after that, and, you know, since I didn't have a driver's license at the time, I started kind of feeling safe, you know, when I hit the city limits of Broken Arrow, because they all knew me. They all knew that I didn't have a driver's license, but the city prosecutor had a chit-chat, you know, at their various, I think they call them guard mounts for the policemen each, you know, shift that's coming on duty, and said, you know, if you ever come in contact with this guy, you know, take no action and immediately call City Hall. And then after discussing things with City Hall, that if you feel that you should do something else in the furtherance of justice, that's fine, but remember, you're on your own. And so many times, you know, we just, you know, smile as I passed, or, you know, hi. And so, you know, I was safe, you know. And somebody, you know, comically thought, you know, they were going to make up some bumper stickers at one time that says, I know Vern Holland, or Vern Holland's my brother. And we're going to put them on a car. And so you can, you know, in addition to winning, you know, and I mean, man, they remember this stuff and get them to leave you alone. You know, it took me about 8 years, but, you know, unless I got outrageous and did something really silly, they didn't want anything to do with me. And, I mean, sometimes I'm wondering, you know, geez, guys, come on. You know? But, you know, they start leaving you alone. One thing I'd like to discuss as far as how the federal government has gotten so out of control is what occurred under the FDR administration. And I found this book, and I've reprinted, you know, just a handful of copies of it. But it was written by an attorney that was a member of the St. Louis Bar in 1938, and he was screaming at people in relation to what was going on at the time, and how they were utilizing two provisions of the United States Constitution to reinterpret the Constitution and enact all of the raw deal policies under the FDR administration, and where all the three-letter agencies came from. And they did, and he explains this. It's something that's critical. It's something that we need to know as far as how they've got this power. You need to know it because you can't attack it if you don't understand, you know, their pretense of power and how the United States Supreme Court has ruled. One of which is and general welfare in Article 1, Section 8 of the Constitution, that's followed by, which is also a taxing provision of the Constitution, which is followed by the majority of the express and specific powers that were delegated by the states via the people to the federal government. The other one is the Commerce Clause. The so-called welfare state and the transfer, etc., comes from a gross misinterpretation of and general welfare. The regulatory state comes from a gross misinterpretation of the Commerce Clause. I was involved in a case with an attorney by the name of Jeff Dickstein, and we had an individual that had an intra-day daycare center that went up to like K1 or maybe K3, I'm not sure, or however they do it. You know, I know they had a kindergarten. And it was in St. Louis, Missouri, or St. Charles, right outside of St. Louis. You know, and that was it. It just operated within the state. Well, the Department of Labor tried to enforce the Wage and Hour Act against them and the minimum wage against this intrastate daycare center. They were in trial. They actually called representatives of Crayola crayons, Dr. Seuss books, Lego and Fisher-Price toys, and Dirt Devil vacuum cleaner to testify that these products were actually manufactured outside the state of Missouri and that they shipped them in commerce to the state of Missouri. Then they called former employees of the daycare center that testified that they used Crayola crayons there, Dr. Seuss books, Legos, etc. And the judge held that since they were using those products that at one time were shipped in commerce from outside Missouri, that the employees were engaged in commerce and therefore could be regulated under the Interstate Commerce Clause. That's the decision from Judge Limbaugh, Rush's uncle. Just incredible. That's what's going on. This is where, they've taken a limited government and they've turned it into an unlimited government. As absurd as that sounds, this is the premise that they're marching pursuant to. Anybody have a PC at home that has a product that was manufactured outside of this country? Okay. Are you engaged in some kind of business activity? Okay. According to that reasoning, that logic, then you're engaged in foreign commerce. Okay. It's just absurd. This is what's going on. It's not some nexus that we entered into. The Supreme Court spells it out in numerous cases as far as how they've done this. And so, that's the basis, when you're taking a look at challenging some of their conduct, that's the basis that you are challenging. I wrote this one manual on IRS third-party summonses, a third-party summons from the IRS, like to a financial institution or some other third party where they want to get information. Now, these type of cases are real tough to win, and on a national average, only about 1 out of 100 individuals win, in a third-party summons. I've got a, substantially better record at challenging these than that, and about 4 months ago, we won a published Seventh Circuit decision on a third-party summons because they failed to strictly comply by making what they call a prima facie showing of 4 elements that the Supreme Court in a decision by the name of Powell said that they had to do. Again, it's due process. And since they failed to do that and make that showing by submitting an affidavit, we were able to reverse the trial court. This particular individual is under criminal investigation, and we're in no great hurry for that investigation to conclude. And we want to do everything in our power to slow it down and show them that we're going to resist every inch of the way. And so that case, and it's on remand now, and it's already lasted 2 years. And there's some additional things that now the judge has got to deal with. And so I wrote, this manual to help people that receive third-party summonses. And it's kind of a no-risk kind of a deal. If you don't challenge, then the third party is going to turn the records over. Worst case is, if you lose, the third party is going to turn the records over, but it might be 2 or 3 years from now. And I've made these cases last up to 3 years and lost every inch of the way, but stopped the investigation dead in its tracks for 3 years. And in the meantime, we've got all these judges that changed their mind about all kinds of different cases, like my criminal case. The Supreme Court kept coming out with new rulings because I kept putting it off so much, and so I was able to make another challenge. And until the U.S. attorney said that I wore them out. I know it was 11 trial boxes, and I know we had almost 400 docket entries on the case. But, I thought we were just getting warmed up. On the Fifth Amendment anymore is really fine-tuned, but, I've got one on first-party summonses. I've never lost a first-party summons. Nobody should ever lose a first-party summons, when they're summonsing you. But I have seen all kinds of individuals, well-intended individuals, get themselves in a lot of trouble because they proceeded wrong. And we one individual out of Michigan, he ended up getting himself incarcerated in county jail for 8 months until an attorney and I could get up to the Sixth Circuit and finally obtain an opinion and get him and reverse the trial court and finally get him out of jail. Now the trial judge was absolutely wrong. Incarcerated this guy in clear violation of his constitutional rights. So what can we do to the trial judge? Nothing. The guy has absolute immunity. There is nothing we can do. And so you've got to be careful the way that you deal with these people because they are exceedingly powerful. One time I had to leave court because I was so furious. I was afraid I was going to do something that I would have to live with. And so I just turned around and walked out of court because I knew better than to mess with a judge. They're powerful, okay? And also they're the ones that are going to be making the decision on your case. And so this guy learned that lesson the hard way. 8 months, for no good reason. I just don't see it, But, we can win, these things every time if you follow the correct process, okay? Recently, Let me get some of my decisions. Last year, we had a great year last year in regards to administrative claims for refund. With the IRS, whenever they seize property, and any amount of the actual tax liability is paid for any alleged tax debt, excluding interest and any penalties, just the actual liability, then you can file a claim for refund. It doesn't matter if you paid it voluntarily, or they seized enough property to do that. And there's so many individuals that let this tremendous opportunity go by. Yeah, and we do have, asking in regards to statutory time periods, we have a statutory limitation of 2 years for the amount of funds that they've seized, where you can file an administrative claim. You've got to follow the process that Congress has laid out, which is an administrative claim for refund first, and either they deny it or is deemed denied after 6 months. I'm going to try to stay away from the technical stuff of it, but then you have another 2 years after that in which to go ahead and pop it into federal court. I settled, worked with individuals, several pro se, one case with an attorney, in 5 different situations just in 1998, and we recovered over $500,000, for these 5 individuals. One of them was, soon to be retired. He is a retired postal employee now, and they had seized a chunk of change, and we followed the correct process. They knew we followed the correct process. They knew that they were wrong. And so we entered into negotiations almost immediately, and about 6 months after that, he received a check for $104,000 in change. One case has been going since 1993 for a case in excess of $150,000 that they seized from a spouse, where they said that these funds were actually she was holding them as the nominee of the estranged or ex-husband. And that's going to result in excess of $200,000 right there. If we let these opportunities go by, and when they called me, by the way, they had 3 days to go on this statute because an attorney had said misunderstood the law and was thinking that they had 2 years where they only had 9 months. And if another 3 days had gone by, they would have lost those funds forever because the statute's limitations are strictly applied against us and against the IRS. That's one of the areas that the guys and gals wearing the black dresses will still enforce. And so an administrative claim for refund also allows you to advance any other issue that you want. And somebody was bringing up the withholding this morning. And so, I'm devising various ways to challenge, the withholding. You don't want to file a W-4 exempt. We used to do that years ago. It's not good for your health anymore to do that because the combination of W-4 exempt and non-filing of a tax return, they equate, the judges equate to tax evasion now. And so you've got to be careful. But there's other ways that you can handle it, and one of which is through administrative claims for refund. For the individuals that have been subjected to withholdings. And, I'm just, trying to get creative and dream up different ways, to challenge that and to recover some of the funds. You can also challenge any constitutional issue that you want in an administrative claim for refund. Congress has limited the jurisdiction of the federal courts as far as what they can and what they cannot do. And so, those are, excellent ways to do it. Another one through settlement for an individual that they had imposed 100% withholding penalty against, alleging that he was responsible to withhold and pay over from employees. And in fact, he wasn't the responsible party, and we proved it, and we settled that case as well. Versus going to trial. We just weren't going to get any other mileage out of it. We bypassed a written decision, and one of my motivations is to get published decisions that's going to help everybody else out. But unfortunately, a lot of the cases that we win are not published, and you can't find them anywhere. And so recently, I've updated my computer. Also, I've obtained a scanner. And so I'm scanning some of these unpublished decisions in, and I'm emailing them out to a couple thousand people and encouraging them to send them on around so everybody knows that the opinions exist. And a lot of them are very well-written opinions. One of which is a Simpson case that we won, I believe, June or July of last year in Florida. And in 1983, Wilford and Janet Simpson had purchased the home, and they titled it in both of their names. But when it comes to property and rights to property, I'm looking for the decision, you know, it's state law that determines those rights, just like in California. And another manual I've got is the property laws of the state of California. I had a handful of those left from some previous seminars, you know, that explain your property laws and how the IRS can attack. You know, so you can take a look at it. You know, they can seize things that you have an interest in, you know, but they can't seize things that you don't have an interest in. And so it's a good idea for real and personal property to understand the way it works here, and even more so since you guys are a community property state. You need to do some planning there, you know, if you're married, as far as severing these relationships out. And, you know, there's a lot of, you know, the time doesn't permit me to go into them. But at any rate, you know, there's several things that you can do. In the Simpsons case, and fortunately, things worked out for them, but they had acquired it as husband and wife. And under Florida law, they have a form of common law ownership called tenants by the entirety. And this form of ownership is only available to married couples. And the law says that neither the husband or the wife has an individual property interest in that home. Or other, you can also have bank accounts in this form of, you know, of ownership in various jurisdictions. And so the IRS filed in federal court to reduce what they, you know, their bogus assessments to judgment, then to foreclose, you know, their liens against this property under, you know, fraudulent conveyance theory, some other nominee alter ego. They had about every theory in the world. They had transferred this property first. You know, Wilford transferred from the property from himself or his interest to the wife. Okay, then she transferred it to trust, to kids. I mean, it just, you know, like 7, 8, or 9 different transfers. But fortunately, they never cratered that original ownership for various reasons. And we said even if they did, and ownership had to revert all the way back through all those transactions to the way that they owned it in 1983, that the property was bulletproof. And that the IRS could not even maintain a lien on that property because they were only alleging that Wilford had a tax debt, not Janet. They could not collect against Janet for Wilford's tax debts. You can create that kind of a relationship in California as well, even though you're a community property state. Because of that, the judge said you can't sell the property. Wilford doesn't have any individual ownership in it, and it was just simply the application and understanding that it states that define property and rights to property, not the federal government. And the federal government can only attach by their liens and levies those property interests that are defined by state law. But, you know, I haven't seen a published decision on the case, and that's one I've recently emailed out to a lot of people to explain the way that it works. You know, if you want real protection, you know, and, you know, this might offend somebody, but forget the trust that go around in this movement. You know, if you want a viable trust instrument, you know, you've got to set it up right, and you've got to maintain it right. So, and in some cases, and you know, we also had another decision about a year ago in state court where we did win on a trust, and they found that the trust was viable. Okay, but you know, they did some you know, some right things. But it's the states, you know, that do have authority over trust, and so you need to adhere to state law, you know, when you set these up to make sure that you have a viable trust that they can't, you know, just carve through. And so you need to understand your state property rights. You know, it saved their home, and in their case, you know, Wilford's a crop duster. They, you know, the home included 27 acres of land, which also included a landing strip, you know, and, you know, their livelihood, et cetera. And so the judge said you can't touch it. Can't ever touch it, you know, get out of there, get the lien off, and they were very happy campers. In Wilford's case, he went ahead and defaulted. He didn't default. The judge found that he defaulted. He wanted to try some issues out. They didn't work, so they got a fairly large judgment against him for taxes, but they don't have anything to collect it against. And I know that tears some of you guys up, and I know you hate to hear it, but you know they just can't collect against him. In another case, and this is the Tulloch decision, and I think that, and this is not one that I had a lot of hands-on with. I discussed it with them, and I first furnished them some pleadings for issues that they wanted to advance. And, you know, I read the decision, and, you know, the judge just followed, you know, our legal issues to a T. And in this case, it was an administrative seizure and sale. It was in the state of Idaho, I believe. Yes, in the county of Madison. And the purchaser, you know, put down a lot of money for this property. And so it was challenged in state court under the State Quiet Title Act. And the judge found that the IRS had sold the trust property versus the so-called taxpayer's property that had been transferred in 1994 to the trust. The purchasers lost their money, invalidated the IRS deed, and now the trust is the owner of the property. In some situations, and you know, we had to be careful about the way it came about, that the funds were paid, we invalidated the seizure and sale of the property, the individuals kept it, the purchaser lost the money, the tax debts were paid, and then we filed, after we won in court, we also filed an administrative claim for refund and got money back. It's just understanding the way these laws work in conjunction with what the judges will rule on. You know, and after almost 20 years of this, I know what the judges are going to rule in our favor on and what they're not. You know, and the reality has taught me that they're not going to destroy the income tax system. You know, it's going to have to be Congress that kills that baby. But the Republicans have started. I can't believe it, you know. Put me out of business. Every once in a while, you know, let me mention one other one, Bartell out of Kansas, another unpublished decision, although it's 22 pages in length and well written, and those 22 pages were preceded by a magistrate's recommendations and report and recommendation that was 16 pages, so we have 38 pages of opinion, and you can't find the case anywhere. But we expanded on why the federal judges have jurisdiction to hear the case, and where it was, you know, the judge ruled in our favor, and this dealt with a procedure due process violation, which I won, you know, probably in excess of, and I'm not exaggerating, 24 cases on this one issue, and recovered and invalidated the seizure and sale of the real property. Under Section 6335 of the Code, they must personally serve notice of seizure and notice of sale. You know, if the seizure occurred within that particular revenue district, where now they've expanded the scope of the revenue districts. But they don't like to do that. It's much easier just to send by certified mail the seizure and sale notice. And notwithstanding the fact that the Bartells had received, you know, and signed, you know, the certified return receipt for the notice of seizure, that wasn't good enough. It had to be personally served. And so the lucky purchaser had paid, you know, quite a few bucks for that property. He lost it to the tune of $30-some-odd thousand, and we recovered the house. Now with the Bartells, you know, they called me on a Saturday, and Friday evening the sheriff had just stopped by and delivered a 3-day notice to quit for an unlawful detainer action in the property. The purchaser already had the director's deed, and so he just said, "Sheriff, move them out, they won't leave." And so they give them 3 days, and that was on Friday. And so, you know, I just discussed through the factual situation with them, and they were literally packing boxes ready to move. And I said, you know, after discussing, I said, if you're absolutely sure that that's what occurred, stop packing. Really? I said, yeah, stop packing. We're going to keep you there. We kept them there, and 2 years of litigation later, you know, we got 38 pages of excellent, excellent decision that you guys will never see. Every once in a while, how much time do I have? Oh, we're done? Oh, we're out? Oh, it's done deal. Okay. Every once in a while, 30 seconds, every once in a while, these purchasers are so frustrated because they lost their money in the property too, that they write to reporters, and we had this happen on another case in Idaho, and this guy was whining and crying like you wouldn't believe. I can't believe my government did that to me. But they did, and so they printed it, and I think, you know, the culmination of, and we've been hitting them this way since like 1987, and we've won so many cases, and the bureaucrats just cannot seem to dot all I's and cross every T, that for a year now we have had zip, that I'm aware of, zip, physical seizures and sales of real and personal property. Thanks, guys.